Morning, everyone. Hello, Monday, and welcome to the webinar today on, we're talking about the Employment Rights Act 2025. I feel like a newsreader because I've got paper in my hands today and a pencil. We're talking about employment contracts and terms and conditions and oh my goodness me. And we're talking about this on the 1st of June at 11 o'clock. Hello and welcome everybody. My name's Amanda Chadwick and I think many of you have met me. If you haven't, can I just before we start, while everybody's logging on, remind you that I will be at the Festival of Work with the CIPD on the 10th and 11th of June. Please come and say hello. Don't be shy. Come to see us. I can't remember which stand it is now, but the CIPD HR Inform stand. I'm also speaking on the 11th at 3 till 3:30 on the Employment Rights Act on the I don't know which stage it is actually, but I'm not very good, am I? But just come and look for the lady with the curly hair and glasses that's walking around. So come and see us on the stand. And that's what I just thought I'd mention that while everybody is logging on. I hope you make it. Right, today we're talking about employment contracts. We are the CIPD HR Inform. What are we? We're a fantastic platform. That's what we are. So if you're a consultant, if you're an employer, if you are in HR and you really want some help with what you should write, policies, but you don't want to do it yourself because you're so busy, you want advice as well, and you want experts to advise you. You want salary benchmarking, you want gender pay gap, you want harassment policies, you want training. We're the one-stop shop for you, and we are trusted. We're the most used in the whole of the UK, and we've got international law on there as well, and we do get international listeners. So hello to the international listeners, and a reminder really that the detail contained within this webinar is based on GB employment legislation. However, what I can tell you is, having worked internationally, that lots of countries follow what we do to be consistent and reasonable within the workplace. So just if you are in Northern Ireland, you are in Ireland or Jersey or the Guernsey or the Isle of Man, sorry, I've got an itch there, just give us a call on the advice service just to give you the right information relevant to you. So that's who HR Inform are. Remember, we tailor make it as well, whichever industry you are in, applicable to you. So what might be gross misconduct in one industry might not be another. And I know we've got lots of HR experts on here, and I really love you so much. And I mean that because you know that I'm very passionate about HR and businesses and keeping them profitable. But we have people stepping out into HR as well. We always have to be patient because they're people that are learning and listen to this to learn as they go along. And also for those seasoned HR, it's just because this is a lonely job sometimes. And I think that just listening to somebody every other Monday, it just makes you feel like you're part of HR. So today, what am I covering? And cheers, by the way, everybody. I went to the races on Saturday. Chester Racecourse, if you ever get there, it's beautiful. It's like, I think it's the oldest racecourse in the UK. So I was dressed up to the nines out at the races, and I was drinking champagne. So I hope you had a good weekend as well. So what are we covering today? Employment contracts, essential requirements. We're talking about the risks of non-compliance, policies and other documentation, and what the implications of the Employment Rights Act 2025 are. Literally 30 years ago, you were lucky to get a contract, you know, actually, even where I live, in some of the companies around here, and I'm not going to say who they are, but still people are lucky to get a contract. But believe you me, at Fair Work Agency, we'll be checking that in the future. So get your acts together. If you are listening or you know people that are running a business and they haven't got contracts in place, warn them that they should have them in place. And there have been many changes to the law that have meant employment contracts needed to be updated in recent years. And it continues now. The provisions of the Employment Rights Act 2025 have started to come into force. If you fail to keep pace with these changes, increases the risk of employment tribunal claims and problems with employees. So you get a lot of, I think when you start, some people who start in HR, you can start this happens to a lot of people. They don't mean to go into HR. If you've seen my LinkedIn post, I didn't mean to go into it. I wasn't at school thinking, yeah, do you know what I'd like to do is human resources. I don't really think it was a big thing then. I don't even think there was a name called human resources then. And it's funny how you fall into it. And a lot of people, what they do is they're working in a business, and the business then realizes there is red tape and they need to get that red tape sorted, and they need to make sure that they have you know, they need to get the red tape sorted. They need to get things in place, and then they realize that the person working in the office that does the admin, that's the personal assistant, the employee assistant, executive assistant, they usually give that job to that person to sort out bits of red tape, getting contracts in. And that's how a lot of people start in HR, and I'm sure that a lot of you have. Actually, I'd love to know in the comments box. So it's stand F35 at the CIPD Festival Work. That's what people are saying. F for Freddie 35. Oh, to be 35 again. Just to really, you know, I think a lot of people start off there and then they're given that role of doing the HR, and they learn as they go along. I meet so many hundreds and thousands of people that have done that and entered into HR in that way. And then they have to make up and find out how to write a contract and what goes in it. And that's usually how people get into HR, and that's usually how they start doing a contract. It's a legal document, isn't it, as well? So I'm going to ask you anyway, before I carry on, what is your biggest hurdle with the up and coming Employment Rights Act contract changes? Is it keeping templates legally compliant? Is it managing risky consultations? Is it training teams on new rules? Is it lacking time, resources to audit, or don't you have any hurdles whatsoever? We're fully prepared. Join in the conversation. Let me know how you started in HR. Let me know on this poll as well. What is holding you up at the moment? What are you finding difficult? But remember, before I even, while you're doing the presentation, there are a lot of contracts out there: full-time, part-time, temporary workers, agency workers. There are part-time workers, full-time. There are, I think I've said that, there are subcontractors, self-employed, and a lot, and volunteer agreements as well. So there's lots and lots of contracts out there. It's making sure you get the right contract for the right job and you put thought into it. And you can see, if you're starting in HR, it's hard to sometimes pick which contract you should have. And it's always nice to have that advice to ring up and say, look, I'm looking for somebody. I want them on a casual basis. And what type of contract should I have, for example? And for somebody to be able to say, well, the contract you're looking at is this contract. And I think that's nice to know. So, okay. And I just, while you're doing the poll anyway, because I've not half of you have voted yet, so please vote. Mike is saying, I'm not really in HR, I'm just leading a 7-person organization. Oh, as I read that out, somebody else has entered into the chat. So let me go back to that. So let me see if I can find that. Vicky says, started as an office manager. Kate said, yes, I started as a PM, managed people and necessary paperwork. Emma said, exactly how I started, a PA to the directors. Joanne says, 15 years in recruitment, then I moved into HR. Oh, hi, Joe in Warrington, hi. And Diane, how much of, okay. Kayla says, morning, Amanda, let's have a look. Oh, Letitia says morning as well. Let's have a look. Okay, let's have a look. Somebody, I'm just reading them out as you're doing the post. Gemma, I started as an office manager 4 years ago, became HR admin, and now I'm an HR manager, learning by on my own. Good. So make sure you listen to the webinars. Connect on LinkedIn. If there's anything I can help you with, let me know, everybody. Sam, office manager, marketing, ops manager, then HR. That's a circle, isn't it? Vicky, I've said you started as an office manager. Thanks for sharing these stories, by the way. Valerie, my degree was policy analysis, political studies, but did payroll in Canada, and they came here doing payroll. It seems I always get HR questions. It's linked, isn't it? Francis says training teams and lack of time. Emma says, oh, where do I find the comments box? You found it, Emma. Georgina, I joined after 20 years of teaching. Wow. Jacqueline said, I started in admin, EA work, PA, fell into HR. I like that, fell into HR. Francis is saying, started with HR, payroll. Michelle, exactly as you mentioned. Oh, I can't. Mike did say, I'm the jack of all trades, trying to keep up with everything. Well, hopefully, I help you today and give you a little bit of an insight. So let's have a look. I think more than half of you have voted now, and thank you so much for anybody that did, because I'm about to share the results of this poll with you, and it just makes you feel like you're not on your own, doesn't it? And in fact, what is your biggest hurdle? 41.7% said keeping templates legally compliant. And then B was managing risky consultations of 14.13%. 14.13%. That shows you how good my maths is. 14.3%. C is training teams on new rules, was 22%. Lacking of time, resources to audit, 17.4%. And 4.4% of you, I'm dead chuffed. I'm really happy for you. And hats off to you. 4.4% said we have no hurdles. We are fully prepared. That is brilliant. So that's where we're up to. Let's get on with this presentation. And I'll go through again, if I can, more of those people that have come into HR. And Emma said she started at 19. As an HR apprentice. I'll be 35 this month, and now head of HR. Well done. That's brilliant. And Alexandra says, back in the 70s, we were still called personnel. And they still call her that at the family company. So the contract of employment includes the statement of main terms. I just want to do a webinar on what people's jobs were now. So let's start anyway with the basics, what you must have in place for a legally compliant employment contract. The contract is the real cornerstone of the employment relationship. It's legally binding document that, and let me point that out, it's legally binding for the employer to adhere to it, because it's a contract. I always say, and for anything you do in life, if you've signed something, it's a contract. Contract law wins overall whatever you sign. Okay, there's no getting out of it, even if you're trying to. It's a contract. So the contract of employment is legally binding for both sides. So if I, as an employer, I get you to sign it, so I sign it and you, the employee, sign it, we've both entered into that mutually agreed contract. So I can't breach that. And if I do, I could end up in a tribunal. If you breach it, there'll be terms and conditions in there that I've embedded, if I'm smart enough, that will claim some of that money back. Okay. So that's it. So it includes the statement of main terms, must be in place for all employees and workers by commencement of employment. It clarifies the obligations between employer and employee. And what it does, it sets the expectations, doesn't it? And remember what I just said there, must be in place for all employees and workers by commencement of employment. So there are people out there that don't even issue a contract of employment, but it's a legal requirement. And the contract is the real cornerstone. Remember, like I said, it's very, very important because, you know, it contains legally binding clauses. So you need to put some real thought into it. To make sure it's meeting a lot of the criteria, being legally correct, protecting yourself, and also building in some flexibility for when you need it. But only so far is legally allowed. And you can have whatever you want in your handbook and your contract as long as it is reasonable. So once it's in the contract and it is agreed, though, you are expected to stick to it. And failure to do that can mean a claim in a tribunal or in another court. So it's important you get good advice on how to word it, and you word it in the right way. The Employment Rights Act of 1996 is the law which covers written contracts. We also call them written statements. The full name under the Employment Rights Act of 1996 is the written statement of employment particulars. Every employee and worker in every industry needs to be given a written statement. There are no exceptions based on industry, job type, or size of organization. I think you need to pass that on to people, that it doesn't matter what size of business you are, this applies to you. If you're an employee or a worker, you have a legal right to a written statement, and it must be given by commencement of employment, so by the time they start working. But you shouldn't give employees and workers the same statement, because it would blur the lines of employment status. Employees and workers have different rights, so you need to reflect that in the statement you give them. And also, you know, there's a big spotlight on self-employed as well. I do really think, and I've said this for a long while now, because I do futuristic HR, I can see where the government and the enforcing authorities are going. And it's almost like they're like, it's relevant to me because I live on a small holding, but it's very much like sheepdogs, and they're rounding up the sheep to corner in on money that they're missing and making money from those sheep, if you like, because the enforcing authorities are, they're looking at things like self-employment. They're looking and clamping down on zero-hour casual workers. They're bringing in the Fair Work Agency, the trade unions, and the HMRC are getting involved. And you get where I'm going with this. I've seen it for a while. And the fact is, with self-employment, people that say their staff are and I'm quite straight about it, and they'll go, no, they've got, we've got a contract that says they're self-employed, and I think, well, that relationship has changed because they've got their own desk. And I think I've told you before about the company I work with, and they said this guy was self-employed, but he had his own desk. He even brought his dog to work. And I've got dogs, and I'm always questionable about bringing dogs to work. And then also there was pictures up in the staff room where he's at every single party since the blooming 80s. And I'm thinking he's definitely not self-employed. And HMRC, Fair Work Agency, everybody would pick up on that. They don't have to be a private detective to work that one out. So self-employment, you might think they're self-employed, but you have to have a contract for services in place. Keep an eye on it. And it clearly should say things like, you don't just work for me, you work for other people. You don't just invoice me, you invoice other people. You're responsible for your tax and insurance. You can send anybody else in your place if you want to, and you can charge what you blooming well want, basically. But obviously in contractual wording, not the way that I'm putting it. And that's one area I think of contracts where people get it wrong. Because the employee is sort of controlling the relationship they want. But it's when you try and end that relationship, things look and end up sour. So core requirements, let's have a look at what the core requirements are. And they're found in Section 1 of the Employment Rights Act 1996. And it includes details such as start date, job description, the pay, and the annual leave details, etc. And since 2020, they should also include information on the probationary periods. And remember, there's a big focus on that, isn't there, because of the unfair dismissal changes in January. And you should really be looking at your probationary period. 6 months, in my opinion, is too long, because that will give people those unfair dismissal rights. You really need to lower it to allow you to go through the process. So 3, 4, 5, 6 months is 6 months cap. That's too long. We want to get all that sorted well before the 6 months. So since 2020, it will include information on probationary periods and paid leave, including statutory family-friendly leave. And the Employment Rights Act 2025 means that contracts will likely need to be updated. There are various items that should be specifically included in the statement of main terms. I'm not going to list them all here, but we do have a template contract available that will have everything you need on there. You don't want this document to be overly long. It's usually 3 pages, and that's just right, I think. Keep it short so you don't lose people with it. It's one of the key documents that underpins the continuing employment relationship, so it needs to be as clear as possible and easily referable to, and easy to read. Don't make it complicated. With the changes the Employment Rights Act of 25 has brought in with regards to statutory sick pay, paternity and parental leave, and the future reduction of qualifying service for unfair dismissal, and the impact this has on probationary periods, it's likely the contracts will need to be changed. So you've got a little bit of work ahead of you there. So don't forget that. Okay, so what if they're not compliant? So employees miss out on key rights and entitlements. The employer is not protected. And workers can make a claim to an employment tribunal, but it is actually, even though the amount is relatively small compared to other tribunal cases, it's just the hassle. It's the stress. It's the backlog in tribunal. It's not really worth it. It's not worth the hassle. So get it right. You don't want that stress. I want you to be preventative. I used to represent in tribunal. It's horrible. It's stressful. It's not nice. People lie and you have to wait. I don't like hanging on to stress or issues. I just want a solution. So that, make it so it's legally compliant. It's not worth the risk. And also it's protection for the employer. So what you can do, and we've got all of this on our platform, we've got things like restrictive covenants, we've got training agreements. They are brilliant, and people go, and they're not worth the weight in gold, and I think that's because they're not written properly. If they're written properly, then they are. So restrictive covenants, inability to deduct in compliance with the law if you haven't got this, and inability to recoup expenses for employee additional qualifications when no training agreement is signed. And if you're not issuing a contract, I know people go, well, it's only 2 to 4 weeks pay, but that's a lot, especially if you've got a bunch of staff. So we've got, make sure they are compliant. So beyond the contract, we've got policies and handbooks. It's ideal to keep your rules and policies together. So an employee handbook is an ideal accompaniment to the written statement, especially as you don't want the written statement to be too long. Otherwise, it takes away from the clarity you need for that type of document. But you'll have so many other rules and procedures that you need your staff to know about. So it's a really good idea to keep them all together in one place. That's where an employee handbook comes in, and they are brilliant. They're what your managers refer to, your staff refer to, you refer to. They manage situations. It's ideal to keep all your rules and policies together, includes organizational values. If you are somebody that puts it on your intranet, don't forget the people that don't have access to your intranet, like support staff or gardeners, cleaners, that type of personnel. They might not have access to the intranet or not use it. So make sure everybody can see it. It should include your organizational values, must be accessible to employees, and it's important to communicate what's in it and where it can be found. Keep under continual review and helps to ensure procedures are applied consistently across the business. So let's have a look at the essential recommended policies and information. You can have whatever you want in there as long as it is reasonable. So we've got essential recommended policies and information on here, and I can think of lots of situations over my decades and decades of being in HR and employment law where I meet companies and there's an issue and they're saying, oh, it's cost us a lot of money, and that it's really grinding them down. There's so many policies that solve situations in the workplace. And so we've got the essential ones here, but I'm going to talk about some of them that I would recommend. Okay, so we've got, obviously in 2003, or was it 2004, can't remember, when you had to have written investigation, disciplinary and grievance procedures. It made common sense. Why did it come in? The tribunals themselves screamed out for it. They said, we're having too many tribunals that could have been sorted out within the workplace, costing the employer a blooming, small fortune. So if we make them investigate, make them have a code of conduct, a code of practice, then it'll prevent them going to tribunal and teach them to handle things properly. And that's what that did. It really, truly did. We'd see so many tribunals that really shouldn't have been there, that could have been sorted out in the workplace by having an investigation, a disciplinary, giving people the chance to appeal with a fresh approach, and grievance procedures in place helps you solve things in the workplace. Health and safety, they say if over 5 employees, you know what? I've worked with companies where they've had accidents when they've had 1 member of staff. I personally would start off as I mean to go on. I would have, excuse me, a risk assessment, for example, already in place for somebody who could become pregnant, which you have to have. So, start off as you mean to go on. And there's so many things in health and safety that there's crossovers with employment law. So when we look at your health and safety handbook and you look at your employee handbook, you've got, for example, I've just mentioned pregnancy there, and you hear me all the time talk about that statement on pregnancy. I don't know when somebody becomes pregnant, and sure as hell, 20 years ago I was saying people can get pregnant later on in life. Now more and more people are. I had my last child at 36. Many people now are having babies later on because they're able to. So, you know, medicine and science has moved on so much, and people are living much longer. So there isn't any sort of cut-off date on that. So what we've got is, it's very important to know if somebody's pregnant, because you should do a risk assessment, and also they're protected. So you don't want to make a bad decision and you don't know somebody is pregnant. So again, a crucial statement, which I mention on every webinar, is in the handbook and the safety handbook, a term and condition that says, if you are pregnant, you have to let us know written at the earliest stage possible so we can implement our health and safety standards and do a risk assessment. The same goes for health. That's in health and safety, but it's also employment law. If you have a medical condition, it changes, you start taking tablets, that changes. You're having counselling, or you're disabled, or you get a disability, or it changes. You have to let us know written at the earliest stage possible so we can implement our health and safety standards and do a risk assessment, both in employment law and health and safety. Basic things like, if you move house, let me know. If your next of kin details change, let me know. If your telephone number changes, let me know. Why? Because of pension and the pension laws. But also, if I am sending you a letter to invite you to an investigation or disciplinary, I need to make sure I've got the right home address. Yes. Or so basic things like, if your driving license details change, you have to let me know. If you get an endorsement, you have to let me know. Things like I don't know. What I don't know, I'm going to put in my handbook. Then we've got the essentials. So we've got health and safety. We've got data protection. Do you remember that coming in? And everybody's running around to find a GDPR data protection policy. Don't worry, we've got it on our platform. But data protection, equal opportunities harassment law, changing umpteen times. You need to have the training. You need to have the policy. You need to have evidence that people have read it and understood it, and that you continually train people. It's now going to cover third party. We've got sickness absence and bullying. So bullying procedures. We've got, and I want you to have the sexual harassment policy separate to the other harassments. We've got sexual harassment separate. I've got so much to tell you. Honestly, I'm getting carried away. We've got sickness absence. So we have, you know, how you manage that, a notification, and access to doctors' records. We've got alcohol policies, where it says no alcohol in work. And they were talking about, I was reading something today about that show Rivals. I haven't watched it yet, but I'm going to watch it because I have lived in the 80s, and what a splendid time that was. And what's so funny is they're talking about alcohol in the workplace and saying it was like essential that you had a couple of glasses of wine in your lunch hour, or, you know, a couple of pints of beer. And actually they did write into contracts, you know, only so many drinks in your lunch hour. People seemed happy, didn't they? And I'm not saying do that, but alcohol policy, especially when you're operating machinery, smoking policies, vaping, electronic cigarettes, pipes. I don't know anybody that smokes a pipe anymore, but they're policies that are essential. And actually, we discover these policies usually when there's a problem, and we think, why didn't we have that in place? And so a lot of these policies have started from somebody else's issue or somebody else's tribunal. But data protection, mobile phone policy, social media, WhatsApp, what people can say, what people can't say, and then things like AI policies, quite a new policy, isn't it? Menopause policies, men's health. There's so many policies out there. Tips where required must provide information on sick leave and pay and pensions, statutory family-related leave. That's just some of them. So, and training and mobility and layoff and shortage of work. Oh my goodness me. I'm like an encyclopedia of policies because I know they're there to support people and help them. So the law on what must be included in a contract actually includes a couple of policies too, either specifically like data protection and health and safety, or indirectly. So if you write a handbook, there are essential ones that you put in place that the law dictates. And then there's ones that within the company you're thinking, this has been an issue before, let's put them in its common sense, like uniform policy, standard address policy, hygiene policy. And I've seen actually just recently some terrible emails that are going out. That spelling on them are terrible. There's no spell checks. They're not even like easy mistakes. They're like stupid mistakes. They shouldn't go out. So you might have an email policy about a standard and a double check, and it just stops, and it's preventative. Wastage policies, things that get broken, these help businesses recoup money, damage to vehicles and cars, that type of thing, or serving clients or customers. So some of the information must be provided in a single document with all the other pieces of info, and some can be provided in another reasonably accessible document like an employee handbook. So, this is just an idea, but a law in place from 1st of October 2024 really rocketed the employment harassment. And again, in October 2024, also the TIPS policies came into play. So if you want any more information on that, contact us. The dangers of not having robust documentation. Well, the danger of not listening to employment law, the dangers of not making a change and putting things in place means that your staff might know more than you. And they are very educated now on employment law, and with the trade unions looming, they will be more so in the future. But if an employer isn't taking proactive steps to prevent sexual harassment, for example, it could lead to EHRC enforcement. So we've got breach of proactive duty to prevent sexual harassment in the workplace. So it's not just going, I've got a sexual harassment policy. That's not good enough. I need to see your training. I need to see that you've had an induction and shown people on day one. I need to have a record of that. I need to see that you remind people every year or every few months about sexual harassment and that you don't put up with it. I need to know that those new starters that haven't got a clue are trained and educated, and that you have that responsibility to protect your staff. So we've got this breach of proactive duty to prevent sexual harassment in the workplace. The maximum compensatory award for not having TIPS policy when required to do so is £5,135. So we've got a lot of arguments for having this in place. The Code of Practice on Fair and Transparent Distribution of Tips says that an employer cannot be said to have met its obligation to handle tips fairly and transparently if individual workers, including agency workers, are not aware of their entitlements in line with the tipping policy. So therefore, the distribution and evidence of that distribution of the policy to staff, whether on paper or electronically, will be required, and the policy must be written in plain language, and employers must provide an accessible format for any worker with a disability on request. And then we've got an example of a tribunal here and processes. And I always say to you, I don't really like talking about employers' tribunals, because some of these companies, they make just a silly mistake and they end up in tribunal and lose a lot of money. And we all make mistakes. We all do. So the tribunal, in this particular case with Briggs versus the trustees of the National Museums of Scotland, the tribunal found that the respondent had failed to follow its own performance policy by not issuing any formal warnings throughout the process. So you've got your handbook, you've got your contract. Remember at the very beginning that you have to follow your own processes. A lot of people ring for advice and that they don't read out what they've got in place. The advice you get should be conducive to what's written down. So the tribunal stated that the claimant has a legitimate expectation that the respondent will follow the terms of the performance policy, and it would be reasonable to expect at least one level of warning prior to dismissal. By failing to do so, the respondent lost the claim on a procedural error. That's a bad one, that. When you lose a tribunal on a procedural error, that could have been so simple. Just follow your procedures, but they lost their tribunal. And you know what? With the tribunal finding that the claimant was unfairly dismissed, and because of that procedural error, they had to pay out £22,000, well, £22,210 and 75 pence in compensation on a procedural error. So this really just highlights the fact, if you don't know, ask and take the right advice. We're here to help you, but also policies, procedures matter, and following them does. The other one is Al NME, I hope I'm pronouncing that right. If not, I'm sorry if I'm offending anybody, versus Buildmaster Construction Services Limited, failure to provide a written statement of employment particulars. The Employment Tribunal accepted that the reason for there not being a statement of employment particulars was because the respondent did not consider it necessary between husband and wife, even though she was an employee of the business. This and the fact the respondent's business was very small meant the respondent was ordered to pay 2 weeks' pay to the claimant for this failure. So what's interesting about this is a husband and wife situation. We always, if you think about employment as a marriage, they can go wrong. And oh my goodness me, let me just sit here for an hour talking about relationships at work and broken relationships and marriages and that have gone sour. And you'll find something like this. There's loads of them to be had and read up on. The other one is George versus Cannell. Employers should not attempt to restrict an employee's activities post-employment without the proper relevant restrictive covenants in place. That's very interesting. Employer tried to enforce restrictive covenants, but were not actually in their contract. And so couldn't, and it exposed the business to risk. So a little bit of a warning there to get restrictive covenants in place if you are. So George is in the background, and George will give you a little bit of a demonstration. We are nowhere near the end of this presentation yet.
Hello.
So don't flit off. Hello, George.
How are you doing?
And I'm fine. Are you?
Yeah, I'm doing
Did you
well.
have a good weekend?
Doing very, very well. Very, very good. Bit of golf, It was nice, chilled out, not too much.
Lovely. And just for the audience, because you get to hear George, and you get to know that we've got producers behind us. George is getting married. What date are you getting married?
1st of August, I'm getting married.
Oh, is it this year?
It's this year coming up very, very soon. Lots to organise for it. Thank you.
Oh, are you organised now?
Yes, we're there. We're sorted.
Oh, brilliant. Well, we all like a bit of good news, so that makes me feel good hearing that's coming up, and it's something really nice to look forward to. So I'll let you do the platform demo.
Perfect.
Okay.
So thanks, everyone. So just quickly, just to take everyone around it, I won't take too much of your time because I know most of you are here for Amanda. So there's lots that's coming out. So I saw the poll at the start. Obviously, a lot of people are worried about what's going on with the changes and being prepared for it. I have been looking through the questions that we've been having as well. So for clients, give us a call. All of them we can answer. They're pretty standard around the contract side of things, terms and conditions, what to use, what not to use. Anyone new who doesn't know about the advisory service, you get unlimited access into an employment team. They can help with any queries, any questions, any cases that you're facing very, very simply. Now, still on brand in terms of tracking and understanding what's happening with this employment law. You've all been extremely busy since April getting things in place. So we give you a nice tracker, very, very easy, 5 subtopics that open up, forthcoming legislations, all the new stuff that we know is happening. All you need to be doing is clicking in, scrolling down, get that added to your calendar. That's then going to pop up for every single one of you that's got it pinned. You're not going to miss it. We aim to get the documents out 6 to 8 weeks prior to that law, so you're ready to go. You'll then have all your recent ones, and then these will be all your new ones that have happened within the last 12 months as well. So the idea for us is making sure that we can make you really efficient, give you that time back, and make sure that you'll be able to follow those laws nice and clearly for you. So that's your tracker. Now, obviously, this is around a lot around contracts, understanding what's happening. So first thing I would do, contract types, and then we will have every single type of employment agreement that you can need as a business and as an organization. So what you can do, open one up. Your basic employment contract opens up very simply, compliant, legally checked for you. We do the work. You just need to go through and infill and select the optionals and either ors that work for you as a business. Now, if you have any questions about it, give us a call and we can obviously help and support with that process of tailoring it for you as well. Now, the other thing, obviously, Amanda spoke about policies. There's loads, right? Loads and loads and loads. So for us, if you go into form an employment contract, click templates. Now, what you want is your checklist for HR documentation. What this will do is help you prepare your business. So it gives you the ones that are essential under the law, the ones that we strongly recommend, and then it will give you every single option available to you as well. Now, we have every single one of these policies on the platform. So the idea is you're not spending time updating and writing, we're doing that for you as well. So the next area was obviously policy, right? So press policies, and then again, we'll make sure that we've got them all for you. So you can click in, you'll have a list of all of your policies. So probation periods is the one that we're looking at and Amanda was speaking about. Open that up and you'll have your probation period policy ready to go for you. Now, we will notify and keep these compliance. Every 7 days, we're sending out roundups to all of our clients to let you know what's going on with your documentation and when you need to make actions to it. And then the last little bit I want to take you through as well is just obviously that manager training. I think it was about 25% of people said, look, they're struggling with getting their managers trained, understanding what they've got to do. Don't worry, we got it covered. So attendance management, looking at the SSP changes, making sure we're managing absence correctly. Click in, go in, press planner, and then what you'll have is everything you need under that one topic: half day, 1 day, 2 day. Very simple. Press half day. That then provides you your itinerary of what's going to be included within that. You'll then have your slides pre-built for you. And then what we do is your activities and handouts as well to give out to make that session interactive. But we'll again notify and update all of that training to let you know what's going on out there and what you need to be informing your managers about. So if anyone wants to have a little bit more of a conversation in detail, do let me know. There will be a Academy link popping up shortly on your screen. Any questions, just ask for George Reed. I'm more than happy to help. And any of my clients, let me know if you need anything from myself as well.
Oh, George,
Amanda,
I've just been looking at all the questions, and Yatunde, Mandy, Yinka, to name it. I've been trying to scroll through. All wish you congratulations, by the way. So they're all saying congratulations, like little messages for you there. So I think that is the poll up. Is the poll up? I can't see it. Is the poll up or?
Let me stop sharing my screen. I believe.
Oh yeah, it's right on now. So while the poll is going on, and thank you, George, for that. Thank you so much.
Appreciate it. Thank you, everybody. Have a lovely Monday.
Where are you having a honeymoon, George?
Oh, yes, I am. Can you hear me?
Where you going? Yeah, just while people are doing the poll. Where? Oh, how fantastic!
I'm going to LA.
That is lovely.
Yeah, so I'm looking forward to it. It's a very, very exciting time. You know, there's a lot going on. It's busy, but we're getting there slowly. Everything's organised. Honeymoon's half booked.
Oh, brilliant!
So we're getting there.
Oh, brilliant. Right. Well, when I was proposed to, my husband proposed to me, and we didn't have a lot of money. He said to me, "Look, will you marry me?" And he said, "But I know you'd probably want to get married quite quick." He said, "So it's either an engagement ring or a honeymoon. Which one do you want?"
What did you go for?
I went with the honeymoon, and I have to say, it wasn't the best honeymoon. It was Madeira, so we just got it cheap off the television. So anyway. All right, well, there you go.
All right. Perfect.
It's all right.
Cheers, everybody. Speak soon.
See you soon. Bye, George. Right. So, okay, I've got while you're doing the poll, I'm just going to answer a couple of the questions because I was just writing down some of the ones I wanted to, because we've had hundreds of them. Okay. So about signatures, people saying about signatures, I really like a hardcore signature. That's what I like. But there's a lot of software now where you get read receipts. So that's brilliant. But evidence at least is good enough. Joanne was asking about notice periods and people not working them. Like I said, I've worked with the care industry really closely for quite a few decades. But I know the CIPD HR Inform, they have like a special section on care. And this is a very, very common question regarding notice periods, which is where somebody starts in a company and then they don't adhere to the notice period and they just leave. And it costs a lot of money. I've done stupid notice periods as well. People give long notice periods, which is not reasonable. So what we've got is you can have something written into your handbook that says if you don't work your notice, we can bill you for that if we're at a loss. So you can do something like that, and it helps in situations, Joanne, especially in the care sector, for example, where it's a good idea for that, because you keep having people leave, and that goes for uniforms as well. Uniform policies where people don't return their uniform or their safety equipment or their laptops or their phones or projectors, that type of thing costs a lot of money for a company. If you add that up, damage to vehicles as well. I mentioned earlier on. Somebody's asking about tribunals made public. Yes, they are. Signature, people carrying on working for you. I'm just rubbing them out as I mentioned the question. But Claudia was saying about not signing a contract. It's always best to get a signature there. But if somebody is working for you, they've had the contract, you've got proof of that, and they're accepting a salary, they're accepting those terms and conditions. So, and Nicola mentioned that back in the day when she started work, in their contract, it said, you're not allowed to smoke before midday at your desk. So that I thought that was quite funny. Quite interesting. Right, I'm going to close that down. So changes to policies and contracts made by the Employment Rights Act of 2025. So April 2026, contractual terms and policies relating to sickness absence, waiting days and lower earnings limit was removed. And these are the essential changes that need to be made to your documentation. Failing to do so puts the business at risk of denying employees their statutory rights, doesn't it? This could happen from something as simple as a line manager. And this is why it's so important to have manager training, because if they're unaware of the changes and giving the employee the wrong information about their rights, then we've got an issue here. So we've got that the waiting days have gone. You should have updated anything you've got on sickness too, and to review that and have a little look at that. We've got the April 2026 contractual terms and policies relating to sickness absence. So the requirement to work the working days and earn above the lower earning limit has been removed. So we've got that biggie, and make sure that everything is, with the current law. We've got contractual terms and policies relating to things like paternity and parental leave. So I've just done an interview actually for the podcast HR-ish, our podcast HR-ish. And actually, on there, I interviewed Blenheim Palace, and it's really interesting, the work that Blenheim Palace do. And I actually work with them. They're a lovely, lovely company to work for, and have been given jobs for hundreds and hundreds of years. But they really invest in young people and growth. But what's quite interesting, they're giving paid paternity for a long time. So that's quite interesting. If you want, that podcast will be out shortly, but that's really interesting because that's exactly what I say. You don't have to do exactly what the law says. You can do whatever you want as long as it's reasonable. So we already saw the change to paternity of splitting the weeks, but now we've got further changes, contractual terms and policies relating to paternity and parental leave, where the qualifying service has been removed. Now, it's not likely this will be in your contract, but what does your policy say on qualifying service? Does it need updating along with any other organisational documentation that you have as a standard notification forms, letters outlining employee rights, etc.? So if you have got them on the intranet, there's nothing wrong with that. Just make sure everybody has them and make sure that those policies and procedures are updated. So, and if you put employee handbooks in the breakout area, make sure everything is updated. So since the 6th of April 2026, we've also got the definition of protected disclosure in whistleblowing legislation has been expanded to include disclosures of sexual harassment that have occurred, is occurring, or is likely to occur. And this may mean that any policies or related procedures need to be updated to reflect the change. So again, there's some changes to contracts and policies. But coming to October, just a reminder also, there's things that happen in the workplace that we will not know anything about because it's happening to you right now within the workplace and you need to change something, okay? So remember that. So where do you think mobile phone policies came from? Because people were using them in the workplace and then employers thought, we need to get something in place to tell people they can't use the mobile phone at the desk. So there are policies. Society really puts things in place and changes what's happening in the workplace. Society has more of an impact sometimes on a yearly basis than anything else. So at the moment in society, we're talking about the impact of more and more people. I know this is I love talking about this type of stuff. I love talking about societal changes, but we've got mental health, haven't we? We've got the use of social media, the surge in the use of the skinny jab, for example, and the side effects of that. We've got more and more people going for operations abroad, or we've got more things happening globally that have an impact on the workplace and people's lives, which then have an impact on the workplace, which then we have to think about ways of managing it. And sometimes that's more complicated than the law that comes in. So it's keeping an eye on what's going on in your business. And if something is changing, give us a call. We'll have an answer for you. That's what we're there for. So we've got trade union statements. So in October 2026, look, we're in June. We're in June. Oh, June. And then, so we've got, look at me, June, July, August, September. And then, so we've got, let's just say 16 weeks, which soon flies. 16 weeks. And then it's the 1st of October. And then we have to issue trade union statements. So are we preparing for that now? All employees will need one. So even if you've got a friend that's got a small business, I don't know, selling sandwiches with a couple of staff, then they will have one. So we've got, under the government's timeline, further changes under the Employment Rights Act 2025 will come into force from October. So we're talking about the employers have to provide a written statement informing workers of their right to join a trade union. This statement is provided alongside the existing statement of particulars of employment at the same time. So when you job offer letter, statement of main terms, and then the letter and statement about joining a trade union. We then got the key points of this include timing of provision. The employers must give this statement to new employees when issuing their statement of main terms, and regular reminders are expected to be given throughout the worker's employment. At the same time, we've then got trade union access, don't forget as well. Check in that you're doing that, and the Fair Work Agency, which has been created. Details of the statement, the form, content, and method of communication will be dictated by secondary legislation following consultations. And a consultation has taken place on this in 2025. A response has yet to be released. And the enforcement on that is failure to provide the statement can result in compensation of 2 or 4 weeks' pay capped at the statutory minimum weekly pay. So if you've got like 100 staff and you've not done it, that's 100 times 2 or 4 weeks, isn't it? It's a lot of money. So capped at the, so I just want you to just issue that statement. And again, we'll have that for you. Proactive duty to prevent sexual harassment. Employers will be required to take the all reasonable steps approach to prevent sexual harassment in the workplace. And this strengthens the current obligation that we've seen, which only requires employers to take reasonable steps. So employers failing to meet this duty may face enforcement action or increased compensation awards. So they're just giving greater protection. And then obviously tips policy, it's there if you handle money, isn't it? Very much like retail, there's rules and procedures we can have in place for retail, but the tips policies laws will be tightened. And then also, I think I missed something else off there as well. No, I think that's it. Yes, I thought of something else. So changes to policies and contracts made by the Employment Rights Act, January. That's the probationary period, isn't it? Because unfair dismissal is changing and dropping from 2 years to 6 months, we need to look at the probationary periods and the probationary policy and the qualifying service to have a look at what you want in your handbook and what works for you. Remember, as we've got, 30 days have September, April, June, November, so we've got 30 days in June. So 1st of July, those people from July, they will fall into that pool. So it's the people you're taking on in July, you need to look at that probationary period as well. So they will be protected, and it's retrospective. So let's remember, normal probation processes are unlikely to meet the requirements of a fair dismissal under the law. So documentation alone isn't enough. Updates to policies and procedures should be communicated to those affected by the changes via training, awareness and campaigns, team meetings and one-to-ones, emails and notifications, and consultation in some situations. So when you update your policies and procedures, you should let your staff know so that they are aware of what's changed. This is especially important for line managers who are responsible for implementing the policies, the first port of call, to avoid them inadvertently denying an employee their statutory rights because they're unaware of the changes. Now, where you are changing a contractual document, you will also need to consult with employees about the changes and get their agreement. This should be relatively simple, especially where the change is a statutory one and is favourable to the employee. So how can we help you? We can help you, absolutely. We can help you with in-depth topic areas on employment law compliance, detailed line managers guides and training, downloadable and customizable template documents, including policies and contracts maintained by experts. And if you don't, we've got all this available to you, regular updates, international law, policies, procedures, advice. We're there every step of the way to help you do your job. Imagine starting in personnel, like I think it was Karen said it earlier on, actually. Personnel back in the 80s when I first started work at the very beginning of the 80s, and having to try and do these documents yourself. We've got everything for you. Let's have a look. And I'm just having a look at some of the questions, see if I've missed any. But summary. HR policies and contracts at the heart of the employment relationship. We'll do a follow-up webinar on this. I think I've answered loads of your questions throughout this webinar today. Don't forget, if you are going to the Festival of Work, I will be there for both days. You can find me on stand F35. You can find the CIPD HR Inform on stand F35. Write that in. F for fantastic, 35. What was I doing when I was 35? I mean, like, not work-wise, because I was doing this, but 35, what was I doing? Oh, I mean, nothing had melted by then. That's certainly the case. Nothing was going down south like I am now. Much younger and fresher at 35. So don't forget that now. That is the stand. Fantastic 35. Catches the festival work on the 10th and the 11th. If you have a question, and we are doing a follow-up webinar here. If you want to, we are on LinkedIn, we are on Instagram. Please join in the conversation and follow us on that. You'll get to know more about what we do. The CIPD HR Inform Pro platform provides support for all things people in HR. If you would like an in-depth demonstration, please fill in the document. Fill in the fill in the questionnaire now. Yes, I have already got support, or actually I'm already a customer. Have a little look at that and fill that in. I hope you've found this useful today. Actually somebody said here, Dee has asked, will you be doing a webinar on the new holiday legislation? We can do. And how often should trade union statements be sent? Lorraine asked. They're saying, well, it's not been agreed yet, but it's looking at every 6 months. So wait and see, because the consultation has gone out on that. So I hope that helps you. Title of podcast is HR-ish. HR-ish. If you follow me on LinkedIn, you'll find it on there, and HR-ish is on LinkedIn as well. Right, so Mawish, hello Mawish, regular listener. And I think we did a trade union webinar actually, Sally, but Mawish has asked, can the trade union statement go into the staff handbook, or does it have to be loan a standing document? Loan a standing document. Okay, so I'm going to close this down now, and just thank you very, very much for listening to us today. If you've missed out and you're thinking, yeah, I would like a consultation, then put it in the message box. Contact us, but we are, in summary, the CIPD HR Inform. You can contact us on LinkedIn and also on 0333 207 5658. My name is Amanda Chadwick. I'd like to thank you so much for listening to us today. Thank you, Anne Shirley Marwish. Thank you, everybody. Magdalena, Amanda. Hello, Amanda, Letitia, Kayla. I recognize some of these surnames. Thank you very much for listening to us today. Gupret, thank you so much indeed. I thank you, George, and the team behind the scenes that you can't see. Gurjit, Megan, everybody saying thank you in there. I can't say thank you to everybody. And Melanie, I recognise your name. We are the CIPD HR Inform. My name is Amanda Chadwick. It's goodbye from me, and it's goodbye from everybody at the CIPD